Hello everyone and welcome to the fourth and final 18 St John Street and Inquesta Forensic Accountants Q&A series on proceeds of crime. This is the fourth live Q&A session hosted over Microsoft Teams live events. For those of us that are joining us for the first time, as a live event you will be able to view slides and presenters but will not appear on screen or be heard. Please use the Q&A button to interact with our producer Stuart, who will pass any questions on to us. This is a closed chat and will not be seen by any other attendees until the questions are passed to the floor. The slides you're about to see will be made on request to chambers. We hope we find this session useful. Please do let us know via the chat box. My name's Andy Evans, barrister at 18 St John Street. Can I introduce my co-presenter, Rob Miller?
Good afternoon, everybody. I'm Rob Miller. I'm a forensic accountant and director at Inquesta. And welcome. Hope this is informative.
Today's session is going to be based on historic transactions and benefit figure. This is an area of interest to Rob because he feels this is a place in which forensic accountants could add significant value to your responses. I happen to agree with him. I'm going to begin with a diagram that I put into a lot of the POCA teaching that I do. It's quite complex, but realistically, it simply tells me where POCA stands. This is how I see a POCA in my head. This is a spider diagram. Hopefully you can make it out. Realistically, what this teaches us is there are three different routes into POCA: conviction in magistrate's court, or by committal for sentence, or by conviction in Crown Court, because you can be committed for POCA solely via this route. These are the three sections of POCA that deal with this: 6, 2A, B, and C. We've then got the setting of the POCA timetable, the 18, the 16, the 17 statements, and then the loop round as the 2 years gets closer and closer of addendum 16 and 17 statements before it's green light and we go to Scott schedule and confiscation hearing. The reason I've set this out is to explain to everyone where we stand today. Which part of POCA are we discussing? Because in the past, in our previous sessions, we've dealt with hidden assets, which fall into this available amount. We dealt with revisits last week, which come in round here, the application by the Crown to revisit the available amount. We dealt with tainted gifts, which find their way into benefit figure here. And today we're dealing with benefit figure more generally. Where does benefit figure, how does benefit figure become generated, and what is meant by a lifestyle case, non-lifestyle, particular criminal conduct, and general criminal conduct. So, Section 6 of the Proceeds of Crime Act 2002, Section 6.4a down here. This is the section in its entirety. This top section is the three-way split that I've just shown in the diagram. This is how you end up being POCA'd. That is to say, you're convicted of an offence at Crown Court, or you're committed for sentence, or you're committed for POCA. And then we've got simply the prosecutor believes it's appropriate to continue to POCA. But down here at question 6.4, as early as that in the process by which a confiscation comes about, is this decision whether the defendant has a criminal lifestyle. If the court decides that the defendant does have a criminal lifestyle, it becomes a general criminal conduct case. I'm going to explain what that means in just a moment. But if he does not have a criminal lifestyle, it decides whether he's benefited from his particular criminal conduct. Particular criminal conduct is basically just what is stolen, recovered, benefited, what the actual crime recouped. However, general criminal conduct is far wider, and because it's a lifestyle investigation, and we'll look at that just now. How do you define a criminal lifestyle? You have a criminal lifestyle if you have been convicted of a Schedule 2 offence, if your offence forms part of a course of criminal activity, or if the offence was committed over at least 6 months and the defendant benefits. So let's split that down once again. Three routes. Is it on the list? Is it part of a course of criminal activity, which is statutorily defined? Or if it doesn't fall into either of those, is it over at least 6 months and has the defendant benefited from it? Let's go down them one by one. Here's the Schedule 2 list. The Schedule 2 list contains 42 separate offences. I have not reproduced them all for you, but you can see here, I'm going to use the shorthand: trademarking, drug importation, supply, PWITs, permitting premises to be used, production, matching offences for psychoactive substances, so not just drugs. POCA 327 and 328, these are money laundering offences of concealing and assisting others to retain criminal property. However, not Section 329, which is the acquisition, use or retention of criminal property. So one to think about there when you're looking to resolve an indictment, which of the money laundering provisions is your client prepared to plead to? If he pleads to 329, at least by route one, he won't have a lifestyle finding against him. Although, as you'll see, the other two routes may come back to bite. The rest, the most relevant I could find, prostitution offences, so that's keeping a disorderly house, blackmail, and again, counterfeit offences under the Trademarks Act 1994, they match up with the copywriting offences under the CDPA at the top if you've ever been involved in raids in Cheetham Hill. That's the Schedule 2 list. As I say, it's not an exhaustive list, but these are the ones I feel we're most likely to encounter most frequently. 42 offences. Check it out. Route 2. What does the course of criminal activity mean? Where no single offence meets the above test, but the Crown submit that the totality of the defendant's convictions on this and other indictments show that he enjoys a criminal lifestyle, then conduct forms part of a course of criminal activity if he's benefited from it, and there are 3 or more other offences from which he's benefited from each one. If in the 6 years, or if in the 6 years ending with the day on which those proceedings were started, he was convicted on at least 2 separate occasions of an offence. So you can look back into previous indictments here. If 6 years before your burglar was charged, proceedings were started, convicted of 2 separate occasions of other burglaries, and if he obtains benefit of not less than £5,000, well, given the prevalence, particularly where I live in Stockport, of cars going missing during burglaries, it's not that hard to find a burglar who's managed to get £5,000 from 3 separate burglaries. Who'd have thought, thinking about what a lifestyle general criminal conduct offender is, that your average house burglar may fall into that category? But look carefully at that second route, because it is wider than you think. Then, the last one. If the offence is committed over a period of at least 6 months, so one offence over 6 months, and you've benefited, well, isn't that every benefit fraud? Anything that makes it to the Crown Court anyway. Isn't that the majority of thefts from employers, those ones where they start off with 10 and 20 quid here and there and end up giving themselves enormous promotions? Isn't it the majority of supply offences of anything, drugs or anything else, or a lot of money laundering? This is really quite wide, I think. If you think about the kind of offences where you do have an indictment period on one count for 6 months. So the headline really is there are 3 routes and they are wider than you think. That's how you get saddled with a lifestyle finding. What does it mean if you get saddled with a lifestyle finding? The impact of a lifestyle finding is found in Section 10. It's quite lengthy. I have paraphrased it here. Please do not quote me, but I believe it says if the court decides that the defendant has a criminal lifestyle, it must assume that the benefit figure includes, after the relevant day, and we'll come on to where the relevant day comes from in a minute, but it's basically going back 6 years from the beginning of the proceedings against him, that any property transferred to the defendant at any stage, any property held by him at any stage, and any expenditure incurred by him at any stage forms part of his benefit. So this allows the financial investigator to go 6 years back prior to the point at which the proceedings began and dig through every single property he held, transferred, or spent. And there doesn't seem to be any limit on this. This could be £2 for a packet of chewing gum in a service station, as far as I can see. Although usually what you're looking here are buying cars, moving houses around, watches which were bought and then no longer appear. This is a sort of mind-bending area of the time frame because of the way it can go back and back in time. However, there is a pushback for the respondent. The court must not make a required assumption in relation to a particular property or expenditure, so cannot conclude that any of these things falling within the 6-year period is benefit and part of the benefit figure if it is shown to be incorrect, or there'll be a serious risk of injustice if the assumption were shown to be incorrect. How do you show that property transferred to your defendant a long time ago is not necessarily the benefit from drugs? Well, that's where Rob's going to come in a minute and try and show you how you divorce those two and prove it with some useful evidence. Before he does, can I just quickly talk about time frame? What is the relevant day? I've alluded to it already. The relevant day is the first day of the period of 6 years, ending with the day when proceedings for the offence concerned were started, or if there's 2 offences or 2 proceedings, the earliest of those days. It is the date of charge in my experience. So flicking back briefly, if I can, what we now know is that any property transferred to the defendants up to 6 years prior to charge, or anything he had, or anything he spent, is fair game for an application of this sort. And what will happen is your section 16 will simply have a date on it. It will say, we assert that the defendant purchased, transferred, or held the following property within the time frame, and they'll say when the relevant day was, because the relevant day, remember, is the date 6 years prior to charge, so you end up with a date back in the past. And it is for the respondent to show incorrect or unjust. How far back can they go? Well, 6 years prior to the date of charge seems quite simple, but if we think about the way the courts are set right now in terms of delay, how about this? 2 worked examples. If your client was hypothetically charged today, that is to say, at the beginning of July 2020, his charge would be now, his first appearance in PTPH here in the Crown Court would take 6 weeks. Between PTPH and trial, we've learned yesterday that bail trials at Manchester Crown Square, at least, are being listed 12 months in the future because of the backlog we all know about. The trial could take 2 weeks. Then the trial could go to sentence. If the sentence is multi-handed with probation issues not helping out, or Newton hearing or change of plea, the gap between trial and sentence could be 12 weeks. Then you've got the 2-year period in which you can be pocket. So that's another 2 years, but that 2-year period is often extended. The time gap between the charge and the confiscation could theoretically run to 3 years and 5 months. That means when you get to confiscation, the time between the relevant date, the first day on which your client's purchases, can fall within his benefit figure if he gets found to have a lifestyle finding is made against him because of the 3 routes. And the confiscation date, the date in which you're in court trying to litigate all this, could be as long as 9 years and 5 months. That's if he's charged today. What if he was charged last year? If he's charged last year, we've got the same sort of time scale. We've got the charge date, the first appearance, the PTPH, there's 6 weeks gone. Then we've got PTPH to his first trial, but if that fell within the epidemic, then you're looking at 7 months to trial, then in a further adjournment through to his next trial. And if he's on bail, that's already 12 months. Then his trial's effective. Then you've got the same gap to sentence, the same gap to confiscation. The time gap between charge and confiscation hearing could be as many as 4 years and 3 months. And the time gap between the relevant date and confiscation could be 10 years and 3 months. The headline being, under lifestyle findings, you may find yourself litigating transactions by your client going back over a decade. How can you challenge that? Well, Rob would suggest you call an accountant. Rob.
Thanks, Andy. It's very interesting you say that about 10 years, because the banks only hold their information for 6 years. So straight away, you're working with your hands tied behind your back. Before I go on to the property held part of it. As Andy said, this session is very much focused on the benefit figure. In previous discussions, we've talked about hidden assets, tainted gifts even, and Section 22 reopenings, which have created some great debate. And whilst we've got plenty of content for this course, it's a really good opportunity to users and abusers. So please do ask as many questions as you can, and ultimately, if we don't get through all the material, then that's not a problem. I'd rather get some questions from you guys listening in on live cases that you've got, and see if we can try and help you out and add any value whilst we're here. As I've said previously, I would say this, but I think it's really important to have some accountancy involvement on most POCAs, even if it's just a matter of calling us to pick our brains and offer any insights which you may not have thought of. The accountancy arguments don't always tie in perfectly with the law, but they certainly can help significantly in negotiation. And as we know, POCAs generally tend to settle. And also, as we mentioned last week, with the increase in the Section 22 reopenings, the importance of the benefit figures increased significantly, and has actually probably made your jobs a lot harder. Gone are the days when you can negotiate on an available amount and ignore the benefit. So the first thing I wanted to talk about is the particular benefit. So Andy, can you move to the next slide? Actually, I think that's not quite in the right order. Okay, yes, so the particular benefit. So it's often thought that there's nothing that can be done with the particular benefit, especially if that's the figure that has been agreed in the original trial. However, sometimes, perhaps often, that's not the case. I just wanted to talk through a couple of worked examples that we've recently been instructed on where we've managed to reduce the benefit figure. So the first case was in relation to airport parking. Mr. M had advertised on the internet for valet parking at an airport. However, the cars weren't always parked where they should have been. Many were thrown in fields and many came back damaged. However, there were periods of time where the cars were parked in the right place, and also the actual complaints they received were fairly few and far between in comparison to the total customers that he had. However, in the particular benefit, the prosecution decided to take all of the money that had come into his account from WorldPay and PayPal as his particular benefit. And that is all the income came in through the internet, and that's why he was using WorldPay and PayPal. Now, we looked at this in quite some detail. All was not as it seemed. How could we split the income by the periods that the cars were parked in various different parking sites? It wasn't as straightforward as you think. The booking records didn't specify which car park they were in. So what we did, with some very careful and complicated analysis, we took all of the booking records, and we were able to identify, bearing in mind that the booking date is not the same as the parking date, and it can be months in advance. We took every booking record and we looked at the date that the date from and where from and to when the car was parked. We then looked at the car parks that were in use at that time at the various capacities based on the defendant's instructions, and we were able to identify or estimate how many cars were parked in specific car parks every day. And from that, we were able to then identify which sales related to the indictment period and which sales related to the illegitimate car parks. And as a result of that, we were able to significantly reduce the particular benefit figure. So that's one area where we've come in very handy. Another area, money laundering cases. Often all the money that's come into the bank accounts can be deemed to be particular benefit on the basis that the defendant's been charged with money laundering. And it is difficult to show where the money has come from, particularly if the work hasn't been done at the initial trial. Again, with some funky analysis and tracing funds through various different bank accounts, we were able to identify precisely enough the sum of money that had been laundered. And again, this resulted in a significantly reduced benefit figure. So just moving on to the general assumptions, the property transferred is generally self-explanatory. More often than not, it includes unexplained credits. The first thing to look at is double counting, because very often there is lots of double counting on the unexplained credits. It's important to look at whether money deposited into one account is linked to the money deposited into another. So I would always recommend, first thing to do is request a copy checks from the banks as soon as is practically possible. Obviously, only if checks are included within the unexplained credits. The banks only keep their records for 6 years, so the longer you wait, the less likely it will be that those checks are available. And frankly, the checks tend to be the best evidence to prove the unexplained credits, because you know who that check's been written out to. Who that check's been received from. Often the prosecution don't make any attempt to get hold of them, but they just include the checks as unexplained because they don't know what they are. And on the bank statements, it's normally just a check number. Now, property held is an interesting one. Andy, can you just go back to the slide before the last one? And again, thank you. So property held is set out in part 2, section 10, and it's defined as any property held by the defendant at any time after the date of conviction was obtained by him as a result of his general conduct and at the earliest time he appears to have held it. So the 6-year rule that Andy was talking about doesn't really apply to property held as long as he held it within that 6 years. He could be holding, he could have had that property for a significant period of time? And at what point does the serious risk of injustice element kick in? Sorry, Andy, two ahead, please. Again, we've had some good success defending the property held. The obvious first port of call is to try and obtain the source of the funds to purchase the property and prove that it wasn't from criminal conduct, which is fine if that property was purchased within the 6-year period. Generally, we can look at that and we can identify where the money has come from. If it's before that, it becomes significantly different. Andy, next slide. I want to go through a couple of examples. Sorry, the slides appear to be not quite in the right order. So this is a case that we worked on. It was a VAT evasion in relation to a chain of Indian restaurants. Particular benefit was only 206,000. Property transferred 500,000. Property held was nearly 1.7 million pounds. It turned out the defendant was listed as a sole or joint proprietor of 10 properties. So there were two arguments that we put forward here and two things that you should look out for. Firstly, the mortgage payments for these properties were made from the very same bank accounts that included all the unexplained credit. And indeed, they were funded from the explained credits. So provided they're on a capital repayment mortgage, it would be double counting to take the unexplained credit and the full value of the property. So they need removing. You know, if the unexplained credits are already in there and the mortgage repayments being sourced from the unexplained credits, to include both would be double counting. The other problem is that many of these properties were purchased 15 to 20 years prior to the POCA, and clearly 20 years ago there was no banking. There's no banking records still available for that period. The conveyancing records aren't really particularly any use, and it's very difficult. You're basically left with the defendant's instructions as to how he purchased the properties and some self-serving witness statements from some family telling you that they gave him £50,000 as a loan at some point in time. Now, none of that is particularly useful when trying to defend it. However, this serious risk of injustice argument is an important one. So it is a perfectly reasonable question to ask whether including properties from such a long period of time that had been remortgaged 2 or 3 times could create a serious risk of injustice. For what it's worth, in my view, it does. I think if it's physically impossible for the defendant, bearing in mind the burden of proof is on the defendant, if it's physically impossible for him to prove where that money's come from and how that property has been purchased, that must increase the risk. Just moving on to the next slide very quickly. So again, this is a very similar situation. I'm not going to go into too much detail. It just so happened we had 2 very similar cases over a very short period of time. Again, 396,000 particular, 135 property transferred, and 744,000 property held. These properties were purchased between 1998 and 2012, most of them in the earlier period. Again, we have mortgage repayments being funded from the unexplained credits, double counting, and they need removing. And again, you've got this serious risk of injustice. So, I mean, my question to you, Andy, we do actually have a question in the Q&A, which I'll come back to in a second. My question for you is, how do you define a serious risk of injustice? You know, is it reasonable to assume that the property that the defendant purchased 20 years ago has been sourced from proceeds of crime?
It very much comes down to what his criminal record looks like, doesn't it? If it's a first-time offender, and if you can, with the assistance of an accountant, show that this is a very long purchased item, so if he's had it for some considerable period before even the beginnings of any evidence that he's committed an offence, you can seek to persuade the other side in negotiation, if nothing else, that they will struggle to satisfy the hurdle of serious risk of injustice. And that's where having evidence, written evidence of where something came from, is so incredibly crucial. Because if we're going back 10 years already to get back to the beginning of the 6-year period, and then in Rob's case on the screen, 15 to 20 years before that, you have with you, and you can prove it, you have with you a very strong bargaining chip to say this is simply an inappropriate thing to be putting in. You cannot seek to prove, or it would be an inappropriate use of the assumptions to show that there's an assumption that this came from crime, when equally the police cannot prove that he's committed any criminal offences at the time. That'll be my approach.
But the big question, Andy, is where do you draw the line? Is it the 6-year period? Is it 10 years, 15 years, 20 years? It's potentially, it's just a bargaining chip, really, that you can go at. I mean, I have no idea, and I assume it's not been tested in court. I don't know what the court's view on that would be. But for me, it just seems it seems unfair, you know, it seems to be a significant punishment. So okay, so yeah, so just going back to that, so there is plenty we can do on the property held figure, and you know, it is something that is worth looking at, particularly on the double counting side of it. Now, Andy, have you got anything further to add to that?
I do, just briefly, you make a good point about the time frame, about the idea of it's not just 6 years, it goes back and back. What Rob's alluding to, in case anyone's confused, it can be any property held during the 6-year period. So if we use my worked example, which means that the prosecution can go back 10 years and 6 months from the date of confiscation. So what's that now? We're back to 2010. If you've got a property in your hands in 2010, but you bought it in 1996, then the prosecution theoretically can put you to proof as to why it should not become benefit figure. And in my experience, financial investigators aren't very keen on trying to push back beyond the 6-year period. And where nowadays, with the huge backlogs we have in the Crown Court, those 6-year periods are going to go further and further back in time. The prosecutors are going to be even more squeamish to go back further and further. What I tend to find is if you go back, usually with a car, I bought this car from that money and then I sold that one and bought another one and another one. If you get a chain of assets and you take it back, maybe not to the day before the 6-year period, but quite a few years beforehand, the trail will usually go cold at that point, and the prosecution will usually roll over because they have no real interest in digging back that far. And at the end of the day, as we discussed last week with the reopenings, the point of the Proceeds of Crime Act is to strip a defendant of the proceeds of his offending. If you can show that this was nothing to do with offending, then realistically, you've got quite a strong argument on injustice. Rob, shall we move to the question, or do you have anything else to add to your slide?
No, I was just going to just further add to that. Again, with the backlogs in the court, it's going to be very interesting to see how this all pans out going forward. So the question that's come through is to you. Well, I say it's to you. It's not specifically to you, but I don't want to answer it, so you can. My client indicated that he does not wish to continue the challenge of a confiscation proceeding brought against him. The proceeding has commenced, and the next hearing is for a full hearing. I'm wondering how to apply to discontinue defence. Is there any prescribed form to complete?
The answer is no, not to my knowledge. In the lower court, if you're dealing with a civil forfeiture, there are certainly forms that go back and forth. The question would be what stage you're at. If you're ready for final hearing, and there's already been a section 16 and a section 17, bearing in mind, I'm going to see if I can put up my diagram actually. Excuse me while I just skip back through the last couple of slides. If you are ready for final hearing, it means you've probably already put in a section 17 and they've already put in a addendum 16. So you're basically here. And if this has gone round and round, the last thing you'll have is the prosecutor's last statement. What I would do is simply put in a section 17 saying, we accept what's in the last section 16. That seems appropriate. And then the prosecutor is aware of what's going on and they can go ahead and make an order on the basis of what's in the 16. This entire process is to do with whittling down the areas of dispute. The Joint Scotch Schedule sets out the area of dispute. If the disputes because of this process or because your client's binned it have resolved to zero, then the answer is to put in a section 17, agree in the entire section 16. There's no need to do one of these because it would be blank, and then you get to confiscation hearing and write it off. That'd be my advice. Does anyone else out there have any other questions in relation to, well, anything we've dealt with over the last few weeks in relation to revisits, benefit figures, tainted gifts, POCA in general? Or does anyone have any clever ideas as to the issue I discovered the other week, which was that when they reopen the available amount, there seems to be no route for the prosecution to reopen a compensation order. Basically meaning that when the entire POCA, once it gets to here, is paid over to the needy victims, any money that then comes, but they don't get all that they need, so there's an outstanding compensation figure. Any money that the Crown recoups this way can't actually be sourced back to them, which seems to be quite an issue. We look at it and we see there are no further questions. Well, everyone, it's been interesting. I don't know if you know, we can't see you. We don't know who's out there. We occasionally find out from people we've met in the course of our jobs that people have been out there. We really hope you've enjoyed this, and we hope it's been of use. If you need to find us, we are here in Manchester. We both practice across the nation. I think a vote of thanks has to go to Stuart Howard Cofield. He is our Chambers fees clerk. He's a sender of emails. He's a collator of invitation lists and our unseen producer of all that you've seen. So thanks to him for every single one of these. I'm going to publish this. Are there any other judges around as random as Judge Lever? His Honour Judge Bernard Lever is, for reasons best known to himself, the allocated POCA judge at Manchester Minshull Street Crown Court. He has in the past asked me to read out all of the documents I intend to rely upon in what is essentially civil proceedings based on paper. It was a strange experience. He seems to make it up as he goes along. He has often said, of course, that the law doesn't apply in his court, and he has the Court 8 rules. Now, all the Court 8 rules basically means is you've got to set out your case in very, very thin detail before you get in there. And that taught me to start doing Scott schedules in every one of my cases. I haven't dealt with it in this seminar, but in most of the others I do, I always tell people the Scott schedule isn't just showing off towards the judge. You can tilt the battlefield in your favour. If you write down all of your points in a succinct and sensible manner, and you write down all the other side's points in a manner that, when you look at it, it just sounds ridiculous, you can automatically slant the judge's view. So I have learned the odd bit of practice from Judge Lever, but the majority of the time he just looks around, finds a pretty girl and gives her the money. He's done that in 2 of my cases. Why should this young lady not get the car that's so obviously hers? And my point being that her dad's a drug dealer who's been pocketed 3 times. So yeah, we don't meet many as random as that. The other thing about him is he takes on the POCAs after the trial. Most judges elsewhere tend to stick with them. Crown Square and Preston, Liverpool as well, they stick with the trial judge. So you're unlikely to get people just coming out and saying, well, I decide arbitrarily to pass this to them, because they already dislike the defendants because they've done the trial. We have a few more. I find the diagram very useful. Can I have a copy, please? Yes, you can. Unfortunately, you've come through as anonymous. But if you email anyone at Chambers, Stuart or James or myself, I've got a PDF copy. That's how I used to teach equity and trusts millions of years ago, was flowcharts, and I do try and find it useful. It's just to do with divorcing benefit figure and available amount and keeping them entirely separate. I'd like to thank, before we end, Richard Chapman, Queen's Counsel, our head of Chambers, the instigator of these sessions. It was his idea to bring Rob and I together. So thanks to him. I'd like to thank my family for managing not to Zoom bomb me over now almost 2 hours, although there's still time yet. And I'd like to thank my co-presenter, Rob Miller. Over to him.
Likewise, Andy, thank you very much as well. It's been very insightful and very interesting, and we've had some very interesting conversations and debates as we've been preparing for these seminars. Again, I just wanted to say, you know, the benefit, I can't highlight enough how important it is nowadays to fight the benefits. And again, even with hidden assets and tainted gifts, all is not lost. We can help. We can do lots to assist the case. So please feel free to get in touch and certainly pick my brains, and I'm sure Andy would say the same. And thank you all for attending. It's been emotional. Thank you.
I'd absolutely echo what Rob said about the benefit figure. I have 3 emails into my inbox this week. Every single one of them, client says he was told just to negotiate the available amount down to 0 and they'd never come back. 3 this week, a few last week. This is going to be what happens to POCA for the next 10 years. Every one of them asking, well, can my client do anything about the bad advice he was given? Can my client reopen the benefit figure? No, he can't. You get one shot at it. Drive down benefit as far as you can. Thank you very much for joining us. Thank you for your questions. Thank you and goodbye.